Court of Justice is now in session. President Issaeva and the Honorable Judges Tinna Goletiani and Sonya Shikhman presiding. The case before the court is the secession and annexation of Agnostica. The parties are Applicant, the Federal Republic of Agnostica, versus Respondent, the State of Reverentia. The Applicant and the Respondent are each allocated 45 minutes to present their pleadings.
Good afternoon. The applicant side?
Yes.
If you are ready, please take the floor. Two numbers.
312.
312.
Good afternoon, Madam President, Your Excellencies, may it please the Court. My name is Maxim Maximov, and I'm honored to represent the applicant in this case. I will speak first for 22 minutes, and my co-agent, Olena Serpuchovitina, will speak second for 21 minutes. We'll also reserve 2 minutes for the rebuttal. I will deal with two first submissions of the applicant and prove the illegality of Reverentia's support to the referendum in Agnostica and the unlawfulness of Agnostica's secession and its subsequent annexation by Reverentia. My co-agent will later proceed with the issue of the termination of the Moot Convention and the removal of software. Your Excellencies, would you like to hear the brief statement of facts? If there are no further questions with regard to the statement of facts, I will proceed to the first submission of the applicant. Applicant submits that the support provided to Reverentia through the Agnostica by Reverentia violated the principle of non-interference, territorial integrity, and the United Nations Charter generally, since first, it amounted to a threat of force against Agnostica, and second, that threat of force was not justified under international law. Moving to the first argument, applicant stresses that under Article 2, Paragraph 4 of the United Nations Charter, a threat of force is prohibited under international relations.
Counsel, are you aware of any examples whereby this court would find a violation of this threat?
No, Your Excellency, the International Court of Justice has never established the existence of a threat of force.
Has it examined these issues in any
Yes, Your Excellency. In the Corfu Channel case and the Nicaragua case. And the position of the applicant in this regard.
Any other proceedings?
No, Your Excellency. The International Court of Justice in its jurisprudence, namely the Corfu Channel and Nicaragua case, has developed the criteria which are necessary to establish a threat of force. First, there should be a demonstration of force. Second, it should be aimed at creating pressure or coercing a victim state. And third, a government of that state should have good reasons to believe that the force will be used against it. Your Excellencies, applicant submits that all these criteria are satisfied in our case.
Including coercion?
Yes, Your Excellency. After the Prime Minister of Agnostica ordered its national police to prepare to prevent the unconstitutional referendum within its territory, the Respondent's president immediately after that ordered its army units to the border with Agnostica. Before that, the president of Reverentia promised to do anything in his power to ensure that Agnosticans would be free. He also offered any assistance required to the head of Agnostican legislature.
But he also specifically mentioned that he will not be moving the troops inside Agnostica.
Yes, Your Excellency, but what the applicant claims in this regard is that this statement should be regarded within the whole policy of the respondent state, and in conjunction with the previous statements.
But is there any special force attached to the statements of presidents of the country? Those are just words.
Yes, Your Excellency, they are just words, but they demonstrate what the intention and the aim of the government of that state was. And in this regard, I would like to address your attention to the dispute between Iraq and Kuwait, where the president of Iraq also explicitly stated that he had no territorial ambitions to invade Kuwait, but the United Nations Security Council adopted a resolution under Chapter 7 and condemned a threat of force of the Iraq against Kuwait.
Well, a few differences though. In this particular case, it's not just what the president stated, it's the fact that he gave specific directions to his forces not to cross into the territory of the applicant. And moreover, he clearly indicated that even though he offers support, they're there to assist any Angrovers who would be escaping into his territory. So it seems to me that despite the fact that he offers this general assistance, his intentions are clearly stated, and particularly the orders are clearly given to the military.
Your Excellency, the statements of the President should also be regarded in the view of the resolution on the crisis in East Agnostica, and specifically in paragraph 5, where it is stated that the President of Reverentia was authorized to take all measures necessary in order to ensure the security and integrity of East Agnostica. Your Excellencies.
Again, it seems to be fairly broad to me, and we have to look to the specifics, and the specific orders he seems to give are not to cross into the other border and to assist only with the integration of other people who are trying to escape violence. So you've got two competing principles. You've got something very specific, and then you have a general broad statement. What you're trying to ask us to do is impute a negative intention to the president on the basis of a general statement where the specific statements clearly demonstrate the opposite.
Your Excellency, this specific statement is just the same specific statement as the President of Iraq issued to its forces, also claiming no territorial ambitions, no invasion in the plan.
Do you know what happened to the Turkish troops on the border of Syria?
No, Your Excellency.
But tell us about, then let's talk about, because this case seems to turn very much in fact. So you keep on referring to the Iraq situation, and pardon me, I'm not that familiar with. So if you want to give this court an example and analogize to us, how is it that the principle, that your point survives on the basis of the facts of that particular situation?
Your Excellencies, the circumstances in that particular case are almost the same as in our case. It was also the tensions between two states, the Federal Republic of Agnostica, and the Reverentia. Also, in order to coerce another state and to create the political pressure, the president of Iraq moved its army units to the border with Kuwait, And similarly, as in our case, we had the tensions and the protests in the part of our province, East Agnostica. And the president of Reverentia, in order to de-escalate the conflict and to create the pressure and aggravate the situation, moved its army units to the border with the applicant state.
But that's not all the president of Iraq did, is it?
In that
situation, because, so listen, you've got 2 minutes for a rebuttal. So as I said to you, I'm not very familiar with the facts of that case. So if the respondent stands up and claims something that is factually completely changes your argument, that will be...
Do you have anything else for the resolution, apart from that situation?
I have one question which actually can help assist you in this argument, to have a clear vision. Your logic is that there was a lawful act of a president. However, this lawful fact becomes at some point unlawful. So my question, because of many reasons, so my question is, do you have any criteria how this court would assess a decision within the sovereign power of a state, of a president, but this decision turns to be, let's say, illegal?
Yes,
what we should look at?
What the court should look at, Your Excellencies, is the circumstances of the case as it was stated in Nicaragua, and also the intention of the party, which is the state of Reverentia in our proceedings. The circumstances of our case, Your Excellencies, is the protest within the territory of East Agnostica and the encouragement of referendum and secessionist movements by Respondent state. When this referendum was scheduled by the provincial parliament, immediately, in 2 days after that, the president offers its army units to the border with the state, which prevents the applicant from taking legitimate actions to prevent the unconstitutional affairs within its sovereign territory.
But how did it prevent you from doing so?
Your Excellencies, we were having concerns about the safety of the people, and we were afraid that if we take any means to impede the unconstitutional referendum, Respondent state will invade us.
That seems to be such a speculation.
Did they state that they are going to do that?
No, Your Excellency.
What did they state specifically?
Under the
moving troops to the border.
that they had no territorial ambitions and that they...
Why did they do it? Did they say? Did they say that they moved the troops just to secure the referendum?
No, Your Excellency. What the...
They said that they want to prevent the fleeing of refugees, correct?
Yes, Your Excellency, to avert the violence.
And moreover, that's what I think we were asking for other authorities, and you gave us the Iraq-Kuwait situation, but wasn't it a similar situation held to be less than, not to amount to the threat of force in the Nicaragua case?
Could you please clarify the question?
Sure. We've already established that there is a principle of non-intervention, right? So I don't think we quarrel on the principle. If they have offered serious help that amount, the only question is, did it amount to the threat of force? And so the question is there any factual authority or analogy, if you will, from a different case that will demonstrate or convince us that what happened in this particular case in fact amounts to the threat of force? You gave us an example of Iraq and Kuwait and claimed that the circumstances are very similar. My understanding is the circumstances and facts of the Nicaragua case actually were also similar, and the moving of the troops near the border actually was held to be not to amount to the threat of force. What do you have to say in that respect? And that's the case. Don't we have a clear precedent that says this action, albeit questionable, does not amount to the threat of force?
Your Excellency, what is different in our case and in the circumstances of Nicaragua is that the President of the United States did not promise to take all measures necessary to ensure the security and integrity of the part of the territory of the Nicaragua. While in our case, the President explicitly stated, it was stated explicitly in the resolution on the crisis in East Agnostica.
What did the President or the Parliament?
It was in the resolution issued by the Parliament of February. And in conjunction with all the previous statements...
Do you know, can you distinguish between the force of the words spoken by, like, in writing by the Parliament and the President of the country? Can you distinguish, like, do you have any authority that would help you distinguish between the force? Because I believe the force of a parliamentary act is different from the presidential act.
Your Excellency, I do not have the source to distinguish these two issues, but what should be analyzed is the general sequence of the line and the general situation. There were statements of the President. Then there was the resolution on the crisis in East Agnostica, which authorized the President to use force on our territory. And finally, there was the placement of troops at the border with our state. Just after 2 days, the referendum was scheduled. All these reasons, all these circumstances taken together provided us with the credibility that if we take any measure to stop the referendum, the force will be used against our state.
Just to clarify, and I'll take you a little bit back into your argument. You mentioned, if I understand it correctly, that you're claiming non-intervention through use of force. Do you distinguish between those two, or it's like basically by showing the threat of force, you'll prove the non-intervention? Aren't those two different violations of international law?
Your Excellency, as it was stated by this respectable court in the Nicaragua case, if an intervention might take a form of a threat of force, and if it takes a form of a threat of force, then it violates both the prohibition of a threat of force and the principle of non-intervention into internal affairs.
And do you claim, I think the President's question is, do you have any examples factual as to what the respondent states did in terms of intervening not under the use of threat of force, but through other actions that amount to intervention?
Your Excellency, we argue only the intervention by the threat of force.
And you mentioned the Nicaragua case and how we stated, but are we bound by what we said in that judgment?
Your Excellency, the International Court of Justice may apply the judicial decisions as a subsidiary means of determination of the rules of law.
According to?
According to Article 38 of the International Court of Justice statute.
And isn't there any specific article which discusses judgments of this court in this statute?
That the International Court of Justice is not bound by its previous decisions.
Just one point to clarify. At the beginning of the presentation, actually, you said that you are supporting your arguments based on the principle of non-interference. And could you distinguish? And now we are talking about the we're talking about the intervention. So could you discuss the correlation between these two principles?
Your Excellency, there is no one approach to the difference between the intervention and the interference.
So you use them as synonyms, that's my question.
Yes, Your Excellency. The position of the applicant that these terms should be treated the same.
In action concerning the domestic affairs, they were actually supporting something that belongs to the international plane, so to say, like self-determination of people. Isn't it a matter of international law? And isn't the state allowed to support things like relating to this level of affairs?
Your Excellency, I understand the question, and this brings me to my second argument concerning the secession and the annexation by Reverentia, the territory of East Agnostica. During the second submission, applicant would demonstrate that the secession of East Agnostica and the annexation by Reverentia were both unlawful, since first, the population of East Agnostica couldn't have seceded on the ground of the right to self-determination, and second, the East Agnostica couldn't have integrated legally to the state of Reverentia. Moving to the first argument, applicant would like to stress on the Article 1 of the International Covenant on Civil and Political Rights, where it is stated that all peoples are entitled to self-determination. If a certain portion of population does not qualify as a people, then the right to self-determination is not applicable. In the travaux preparatoires of the ICCPR, the minorities were clearly excluded in the terms of all people. And in this respect, Your Excellencies, we submit that the population of East Agnostica is a minority, but not a people.
How do you establish this?
Your Excellencies, the UNESCO group of human rights experts concluded in its report the two distinguishments by which the people are different from the minorities.
Why do you care about this opinion? Is it any source of authority for this court?
Yes, Your Excellency, it can be referred to the writings of the highly qualified scholars.
Who was included in the UNESCO group? Do you know names?
Among them, there was Antonio Cassese. And Your Excellency, this UNESCO group of human rights report was also referred by the African Commission on Human Rights.
I'm sorry, are you actually arguing that they do not meet the first requirement of self-determination of people? Is that are you?
Yes, Your
You have
Excellency.
8 minutes left. But
Yes, Your Excellency.
your government itself gave them cultural autonomy, calling them specifically peoples, and now you're representing your government today. This is the hill you want to die on?
Your Excellency, we submit that they are the minority, and that's why they were provided with the cultural rights. But we do not submit that they are the people.
Okay, so let's talk about it. So since you insist on doing that, let's talk about it. So they are, repeat that statement again, they're not a minority?
They do not qualify as a people under the terms of the right to self-determination, but they do qualify as a minority.
Okay, so what's the definition of people?
The people is a group of human beings who share common ethnicity, cultural, religious, and linguistic unity, and have the will to be identified as a separate people.
Which one of those do they not meet?
They do not meet the will to be identified as a separate nation.
They held a referendum. They held a referendum. They are demanding cultural autonomy. The whole conflict is about the fact that they have a will, that they have certain cultural needs, medical needs that, I mean, really?
Yes, Your Excellency, since the referendum was on the question of secession, but not whether they consider themselves to be a people.
Oh, right. So your suggestion is what they should have done and said, by the way, before we hold this referendum, we consider ourselves people, and that would have satisfied your requirement?
No, Your Excellency.
Okay, so what would have satisfied it?
The people should have a consciousness of being people and demonstrate their self-identification for a long period of time. And the minorities do not have this will. And moreover, the President of Reverentia has always...
The minorities do not have what will? To identify themselves as people?
Yes, Your Excellency.
Minorities do not... Do you understand what you're saying? Minorities do not have the will to identify themselves as people.
Since they belong to another people who live in another state, namely the Reverentian state.
Yeah, maybe the other people don't want to identify them as people, but certainly the minorities have the will to be identified as people.
But what happened when Reverentia called those people back? Do you remember the facts in this respect?
Yes, Your Excellency, they refused and decided to participate equally in the politics and the economy.
As a distinguished group who had distinguished cultural interest and autonomy provided by your own country.
Your Excellency, these cultural distinguishments and the common history and the background is the same as the ones possessed by Reverentians.
Council, question. So do you or do you not admit that your country granted them internal self-determination?
Your Excellency, the right to self-determination applies only to people, but not to minorities.
Which one? Both internal and external?
Yes, Your Excellency.
And why is it granted to... what is internal self-determination?
The choice of the political, economical, and the cultural system within the existing borders of the state.
And Agnostica didn't have it. That's your claim, that they didn't have it within Agnostica.
They had the opportunity to preserve their culture and rights.
But they didn't have, so answer the President's question. So is it your official position that they did not have the internal self-determination?
Your Excellency, they had the opportunity to choose what the way of living they wanted.
Not the question.
Which component of the internal self-determination they lacked in Agnostica?
Your Excellency.
So what are the criteria for self-determination?
You just mentioned them. So which one is missing?
The will to be identified as a separate nation. Your Excellencies, I understand your concern. If this court doesn't accept that the population of East Agnostica does not qualify as a people, as a minority, but constitutes a people, the respondent, the applicant will claim that even in these circumstances, they cannot unilaterally secede on the ground of the remedial secession, as it was raised by the written submissions of the respondent.
One question. Let's assume that we disagree with your arguments as to people. You are bringing the remedial secession at the moment. So, and let's assume that they are people, so they have the right for self-determination, which may or may not include external self-determination. So my question is, what is your government's position with regard to the right of self-determination, including internal and external self-determination, and what is the difference, or if there is a difference, between the external self-determination and right to remedial secession, and which one would, if any of these rights are existing here?
Your Excellency, the right to remedial secession includes the opportunity of certain portion of population to secede unilaterally from the state. The right of the external self-determination only includes the really choice of the political system and in the international plane.
Sorry, the right to internal and external determination lies within the political will of the part of the government?
No, Your Excellency, it lies within the scope of the choice of people.
Within the scope of the choice of people? I'm sorry, I don't understand that.
It is the people who determine their own fate and choose the political, economical, and cultural system.
Right. So then, what's the distinction between internal self-determination and external self-determination? And what do you claim, I guess, as the wrong done here, and why they did not need either the external self-determination or the succession?
Your Excellency, in order to qualify for the remedial secession and external self-determination, the people should be the victim of the serious human rights violations and have exhausted all available means of negotiation within the parent state prior to secession.
Okay.
And in our case, Your Excellency, it is not the Kosovo or Bangladesh where the people...
Just one yes or no question. So for you, these two terms, external self-determination and remedial secession, are synonyms again?
No.
Yeah.
You can
Your Excellencies, the remedial secession does not apply in our case, since it is absolutely different as the one relied on by the respondent, where the people in Kosovo, for example, case, were the victims of the ethnic cleansing, and also the more than 1 million of people were displaced. In Bangladesh, it was 1.5 million, 500,000 people who were killed during the suppression operations. It is the flagrantly different from our situation, Your Excellencies. Therefore, we submit that the people of East Agnostica, if accepted by this court, do not qualify as the ones who may invoke the right to remedial secession. May it please the court.